Good evening and welcome to this session of the virtual coaching classes organized by the Board of Studies of the Institute of Chartered Accountants of India. In the last class, or the last session, what we did was we started discussing about the incorporation of a company, etc. I showed you how a company is incorporated, the various rules relating to that. Okay. We discussed about the documents to be filed along with the Memorandum and Articles of Association. Fairly simple process. Now it's called SPICE Plus, Simplified Pro Forma for Incorporating a Company Electronically Plus. Today, I'm going to take you beyond that. We also saw the concept of a one-person company, how to incorporate that and all that. Today, we are going to talk about other matters relating to the incorporation. To begin with, we will talk about formation of companies with. Now, conventionally, I think people have been using this term casually. We call these companies as not-for-profit companies, NPOs, not-for-profit company. Yeah, there are many organizations where the goal is not to make money. Nevertheless, even such organizations would generate a surplus. Any activity could result in a surplus, not necessarily a profit. But then this surplus, or if you call it a profit, if any, in these cases will not be distributed among its members. A for-profit company, a normal company, would distribute its profits to its members as dividend. One. Or else, if it is retained, finally when the company is wound up, the assets of the company would be sold and the amount which is available would be distributed to the members. Now, a company with charitable objects is not supposed to do that, right? So, the Companies Act has made a provision for formation of companies with charitable objects. I'll tell you the reason. You need to really understand how our country's laws are structured to understand this. See, the constitution of our country has three lists: the union list, the state list, and the concurrent list. So while forming the constitution, we had two separate clear-cut governments. We had something called the central government and we had something called the state government. Each of these governments were given powers by the constitution, which is contained in these lists. The state list, or the central list, or the union list as it is called, enumerates matters on which central government can enact laws. Whereas the state list gives matters on which only state government can enact laws. And then you have something called the concurrent list, where both can enact: health, education, formation of societies for charitable objects and all that. Societies registration, there is a central law, but you also have separate state laws. Maharashtra has one, Tamil Nadu has one. So the point here is these are concurrent list activities, which means many charitable organizations are formed within a state and they operate within the ambit of the state legislature, the state act, as a society under the state act. Or you could have a trust operating under the state trust act, though there is again an Indian trust act. Now, suppose a charitable organization wanted to have activities across the country, then it would be better for it to form itself as a company under the Companies Act. Reason, the Companies Act is a central law. Its operation runs to the entire country. So, a company which has formed under the Companies Act can operate anywhere in India, except that it has to it has to indicate that it has a branch there and it will be governed by the central government. So therefore, some large organizations which have countrywide operations or larger goals to expand across country may prefer not to go under the State Societies Act or a Trust Act, would rather form themselves as a company with charitable object. Now, this particular provision is contained in Section 8 of the Companies Act, Section 8. That is why these companies are also known colloquially, and I would say not a good idea. Do not use this word, but even I will use it occasionally while speaking. Section 8 company. Section 8 company. No, but if you are writing in the exam, you should rather write company registered under Section 8. Company registered under Section 8. I know this sounds very long-winded, but my dear friend, these things make a big difference in the exam from the examiner's point of view. So, see, Section 8, even I've used the word Section 8 company on my screen here. And these companies are referred to as Section 8 companies. In those days, the parallel section in the Companies Act 1956 was 25. So these companies earlier used to be called Section 25 company. Now they are obviously called Section 8 company, right? No, can I use this wording? You can, but it's sloppy. In my very puristic view, it's sloppy usage. But okay, come on, it's okay. But then don't do it. If you want to be puristic, if you want to be, seen as a erudite person, do not use the word Section 8 company while writing answers in the exam. There you write a company registered under Section 8. Okay. Now, such companies which want to, you can even go to an extent. I will tell you later, instead of using the word registered, you can actually use the word license. Friends, for a very, very emergency need, I need to just mute for 2 minutes and get back. Give me. I'm dreadfully sorry for that. It should normally not have happened, but that's how it is. So, so these companies which want to be registered under Section 8 should have objects relating to promotion of, their object should be to promote commerce, art, science, sports, education, research, social welfare, which would be very important there, charity, religion. Why not? The religion can be, nothing wrong in having an object as religion. What you will not get is Section 80G under the Income Tax Act. That's all. Otherwise, even you could get a 12A exemption from the income tax you can get. But what you will not possibly get is 80G because you are having a religious goal. Protection of environment, blah, blah. Okay. Now, the point here is, these are generic objects. See, these are very socially important objects. So you can form a company and get it incorporated under Section 8. More importantly, these companies should agree by their articles, they should confirm that the profit, if any, do you notice that if any, because there may not be a surplus, there could be a deficit also. But if there is a surplus or a profit, such profit will be used in promotion of its objects only. Means it will be plowed back for promotion of the original objects. And dividend will not be distributed by these companies. Dividend should not be distributed, right? Also, now see, this is the real point. When you go under Section 8, what you actually do is you incorporate a company, and along with that, the central government not only registers the company with limited liability, but it also licenses you. The central government gives you a license to remove the words limited or private limited. It's a license. The word license in normal, if you want to know the meaning of the word license, it means permission. When I license you or when I give you a license, actually I give you a permission. Your driving license is a permission subject to certain conditions to drive a car or a two-wheeler or whatever it is you have. So a license is basically a permission. So the central government is giving you a license to dispense with the words limited or private limited, as the case may be, from the name of the company. So suppose I'm forming a company under Section 8. Okay, whatever. So, for example, Leadership Research Institute Limited. Leadership Research Institute Limited. Right. Now, once I go under Section 8, the central government will permit me to remove the words limited. So, my company will be called Leadership Research Institute, and it will be registered under Section 8. Many famous companies are registered under Section 8. To my knowledge, the Bombay Stock Exchange is a Section 8 company, and rather Section 25 company, because when the Bombay Stock Exchange was formed, there was no Section 8, right? The Madras Race Club, to my knowledge, the Presidency Club, where I am a member in Chennai, is that I know 100%. The Presidency Club is a Section 25 company, because many times, they've had some doubts and all. I was there on the panel to answer that question on the bylaws and stuff like that. So they are a Section 25 company, right? Like I'm sure in your city, many big clubs or etc. They will be having. They would have been licensed under Section 8. Check out. Don't ask me offhand. I may not know. So don't, in the query pad, please do not put the name of the company and ask me if it is a Section 25 company. But if you do, if I don't, I will say I don't, because I don't have a register of Section 8 or 25 companies with me. The registrar has. So if you have a doubt, you can always go to the MCA website and verify there. Okay. But the chances are large charitable organizations, clubs, social organizations would be Section 25 companies, or I use the word Section 25. Parallelly, it is synonymous to Section 8. Right? The registrar shall, on application, register such person or association of persons as a company under this section. Yeah, many stock exchanges are Section 25. The chambers of commerce are mostly Section 25. Chambers of commerce will be mostly Section 25. You will find. The Hindustan Chamber of Commerce, where I am a member, is a Section 25 company. I'm giving you, obviously, the examples I give you would be Chennai examples, right? So you will have to find out in your own city whether there are any Section 25 companies, right? Section 8 companies. Now, once a Section 8 company is registered, the company will have the same privileges and obligations of a limited company. Otherwise, it's a company limited. Okay, but it will be for the promotion of the objects we stated. No, the profit will be plowed back into the objects, no dividend. Subject to these conditions, everything else applicable to a limited company will apply with certain changes to this Section 8 company also. Normally, a firm may not or cannot be a member of a company. Why? Because the shareholder should hold the share in his own name. So for that, either the shareholder should be an individual or it should be a body corporate capable of holding assets in its own name. A firm is neither. A firm is not a natural person. A firm is not a body corporate. It has no entity independent of its partners. Partners may hold shares in their own names, and that could be shown in the firm. But firm cannot be registered as a member of a normal company. But a firm may be a company, member of a company registered in the Section 8 exception. A firm. For example, the Bombay Stock Exchange would have many brokers who are firms, and they could be members of the Bombay Stock Exchange. Whatever. Okay. Bombay Stock Exchange Limited, if I may say so, or BSE. It depends. I may be wrong on BSE because maybe they have now converted into a company after post-demutualization and corporatization. Chances are they might have come into the normal stream. Yeah, chances are that. So maybe we might want to relook at BSEL because maybe there was a big move in SEBI called demutualization and corporatization. When that happened, some of these guys had to come out and they got into normal category. Alteration of Memorandum and Articles. So a company registered under this section shall not alter the provisions of its memorandum or articles except with the previous approval of the central government. Later on, we'll be seeing provision or procedure for alteration of memorandum and articles. There you will find absolutely there is no need for approval of central government for alteration. Friends, when you want to change the name, when you want to change the registered office from one state to another, etc., you will find there is an element of intervention by central government. But for just altering your memorandum, a clause therein or articles, there is no need for central government approval. But a company registered under Section 8 needs to get the approval of the central government. A company registered under this section may convert itself into a company of any other kind only after complying with such conditions as may be prescribed. Okay. Once it wants to convert itself, for example, a Section 8 company may want to convert itself into a normal private company, in which case it has to amend its articles, include the private company articles there, remove this non-distribution of dividend clause, blah, blah. I seriously don't know why they would want to do that. For all the trouble, it would be easier for you to form a new private limited company. But still, if they want to do that, they can by passing a special resolution. Okay, but a Section 8 company cannot be converted into a one-person company. It cannot become a one-person company. Nor can a one-person company be, a Section 8 company cannot be formed as a one-person company. Got it? And one-person company cannot be converted into a Section 8 company. Got it? Okay. Now, yes. In case, see, the purpose of this company is to promote social objects and to, be a good influence on society. Now, in case the company contravenes any of the requirements or the conditions of this section, suppose instead of promoting social welfare or whatever, they do all sorts of nonsense activities, then the central government may revoke the license of the company. Revoke means to take back. I revoke the license means I take back the permission. I permitted you, now you take back. What will happen? What was the license in the first place? To dispense with the words limited or private limited. Once the revocation happens, the company will again become a limited or private limited company, bound by all the rules and regulations of a limited or private limited company. Okay. So this revocation will happen when there is any contravention of the requirements of conditions of this section, or the affairs of the company are conducted fraudulently or in violation of the objects of the company, are prejudicial to public interest. See, they form a music society. The idea is to promote music. Instead, they start doing all nonsense. They start, doing some illegal activity, collecting money and not providing services, whatever. It's illegal, prejudicial to public interest. Stop. Okay. But before such revocation, see, that word public interest is a very powerful word. It's wide enough to include anything. See, suppose a Section 25 company was formed for promotion of music, and they claim that they are at the highest level of music appreciation, and they started recognizing musicians. Now, if they start recognizing all sorts of donkeys, ignoring the real good musicians, that itself could be a violation of public interest. And somebody could complain and say, I am a Carnatic music sort of fan. And this guy is, this Sabha or whatever this association, which is a Section 8 company, is doing nonsense. They are promoting all sorts of untalented people. So it could be a ground. And they could say, sorry, you are not maintaining the level at which we thought you will operate. But then, whatever the complaint may be, whatever the decision of central government may be, before revocation, the central government must give a written notice of its intention to revoke. And also, an opportunity to be heard in the matter. This is again very important. Every citizen of a democratic country should be given, actually, here the word opportunity is used in the section, but I would add one more word, which is not there, but still it is there. The court will give importance to it. Even if it is not there, they will say it is not enough if you give an opportunity. You should give a reasonable opportunity. There's the ocean of difference there. in giving an opportunity and a reasonable opportunity. Recently, in one of these faceless assessments, the assessing officer sends us a notice, that too on email, today. And he says for a 5-page notice, we have to give a reply in 48 hours. Not even that, 24 hours. The next day. I'm receiving the email today. He says tomorrow. No, agreed. You have given me an opportunity. Is that a reasonable opportunity? So we objected. But nevertheless, he passed a crazy order without considering our. Even then I replied. Within 24 hours, I replied. But he ignored the reply and he passed a nonsense order. So we went to the High Court of Madras. And within 4 days, I got the order quashed. On the grounds that a reasonable opportunity was not given to the assessee to be heard in the matter. So it's a very, very powerful point. And even if, as a future practicing chartered accountant or a member in service, appearing before government authorities, always gently point out that, sir, I need to be given a reasonable opportunity. Don't be rude or, don't be offensive. But at the same time, gently point out to the central government, to the officer of the government, sir, please give me a reasonable opportunity. What is reasonable? Sir, 15 days time you give me. I give you my reply. 15 days is reasonable opportunity. I need. No. Then what will happen? He will say 30 days reasonable. No. I can't give you 30 days. Give me 20 days. Like, you got a negotiation there. But then a reasonable opportunity has to be given. And this is very important. Since you are all students of law, going beyond company law, try to understand the importance of these words. Public interest, opportunity and reasonable opportunity. Because this is common to all law. Income tax, GST. In case some of you want to become specialist in GST, I want to be an expert, whatever. You need to understand these principles of law. Now, when a license is revoked, the central government may, by order, if it is satisfied that it is essential in the public interest, direct that the company be wound up under this act. Why? Because the company has done so much nonsense, it has collected public money, etc. Therefore, it is better for the company to be wound up. But when such an order is to be passed, obviously, the company should be given a reasonable opportunity of being. Here they use the word reasonable opportunity. Okay. Friends, don't even make me start on this so-called Companies Act 2013, drafted by people who do not know drafting. Okay. I'm sorry to say that they are not legally trained people, neither are they lawyers, nor are they like me, people who have been trained in drafting. These are people who think they know. Blah, blah, blah. This is the problem. See, the standardization is not there. Nobody, just like that, as and when you get an idea, you put it into the act. No, not like that. Okay. Anyway, this is the law we are left with. This is the law, unfortunately, that I have to teach. I'm doing my best to teach you this law. Where a license is revoked and where the central government is satisfied that it is essential in the public interest that the company should be amalgamated with another company. See, instead of winding up the company, they will simply revoke the license and say, this company will amalgamate with another company with a similar object. So, and they will be merged. It's good. At least the activities will continue. Okay. Right? These are all fairly simple. On the winding up or dissolution of a company registered under this section, so even after satisfying all the debts, means after paying all the loans, etc., there may still be some assets left. Such assets may be transferred to another company registered under this section and having similar objects, in addition to such conditions that the tribunal may impose. Why? Because this money cannot be distributed to the members. So who will take it? You have to form another company with similar objects and transfer it. Finally, no other organization is there. I am unable to transfer the asset. Then the tribunal may say the assets will be sold and the proceeds, means the amount collected on the sale. Proceeds means the amounts collected on the sale of the asset. That will be credited to the Insolvency Bankruptcy Fund, IB Fund, formed under 224 of the IBC, Insolvency and Bankruptcy Code. Okay. So it will be available with the central government. God only knows what they will do with it, but it will be there safe. It won't go to some people who will misuse it. It will go to the central government. It will be kept safe. Okay. A company registered under this section shall amalgamate only with another company registered under this section and having similar objects. You will notice that these conditions are all fairly logical. What is the purpose of these conditions? To ensure that a Section 8 company will only be engaged in the objects for which it is registered. It should not try to move away from that. Therefore, they insist on similar objects. The Section 8 company is given certain, shall we say, privileges. Later on, when we come to management and administration, we will talk about general meeting. And for calling a general meeting, notice is to be given. Advance prior intimation. Now that normally should be given 21 days before. Clear days. We will be seeing that clear days in detail when we come to management and administration. Don't worry. So right now, we have to give 21 days for normal companies. But for Section 8 company, you can give 14 days, lesser days. Advance notice can be given 14 days before. Need not be 21 days before, right? See, my guru, Professor K. Sanantharaman, always used to refer to Section 8 companies as licensed companies or companies licensed under Section 8. Possibly that is the most elegant usage ever. Companies licensed under Section 8 or licensed companies. He used to use that word, licensed company. I also used to prefer it while writing in my book or when I'm writing an article, etc. I would use licensed company rather or a company licensed under Section 8 rather than Section 8 company. Anyway, while normally typing a query or message, you can write Section 8 company, no problem. Requirement of minimum number of directors, independent directors, etc. does not apply. This will not be possibly clear to you now. But when you come to final, please remember, for a licensed company, minimum number of directors condition, independent directors and all will not apply. Similarly, other companies have to constitute a nomination and remuneration committee for appointing managerial personnel, a key managerial personnel. Similarly, they have to form a shareholders relationship committee. All that blah blah is not there for this company, licensed company under Section 8. Yesterday, somebody was asking me to define key managerial personnel. Very simple ones. Managing director, manager, directors, whole-time directors, CFO, company secretary, any other person designated as, shall we say, responsible for any particular legal duty. For example, if you have nominated a person as in charge of accounts, that person will become a key managerial personnel, KMP. Definition, Hannah, just see that. Similarly, another query was asked yesterday, which was about small company. I'll take it up 2 minutes later. If a company makes any default in complying with any of the requirements laid down in Section 8, the company shall, without prejudice to any other action under the provisions of this section, be punishable with fine, which shall not be less than 10 lakh rupees, but may extend to 1 crore. And every officer shall be punishable with fine, which shall not be less than 25,000, but extend to 25 lakhs. So company, 10 lakh rupees up to 1 crore. Officer in default, who is in default, who has committed the offence, 25,000 rupees up to 25 lakhs. There was also a punishment by way of imprisonment in this section, in this particular clause, which has been removed in 2020. Not relevant for your information. So in case you have an older version of the book or you are referring to an older text, you might find imprisonment is being mentioned as a penalty, but that has been amended. Right? Fantastic. We finished Section 8. So this brings me to a logical stop. So I can take up any queries are there. I'll just check any queries are there. Then I will. So many of you are greeting me. Good evening. Let's see who are all here. We have Hitesh is there. Very good. And Pooja ji is there. Not Pooja Gajar. Your Pooja Dayaram. Okay, good. And Jayendra, excellent boss. Welcome. Siddharth Mudaliar, welcome, sir. How are you? Wonderful. Nice to see you. Here. Okay, blessings are given, sir. So that's what I was wondering. Why Siddharth Mudaliar is attending this session? Good show. Wish you all the best, Siddharth. Hoping to meet you all as members of our institute very shortly. Okay. When you will share these notes? Boss, again and again I'm telling you, notes will be shared on 21 or maybe 21. 22 it will be shared. 21 it will be shared. On the 21st it will be shared. Last class of this topic it will be shared. Okay, being human, Patanjali Ayurveda, excellent. Beautiful. But sir, in Section 8 company, are the salaries? Yeah, why not? Salaries can be paid to employees and all. Yeah, why not? See, employees, what you're saying, you will not pay dividend to the shareholders. Akka salary. In fact, many Section 8 companies are huge employers. They pay huge salaries to their employees. Please explain reasonable opportunity in Hindi. That is a good one. I am not familiar with Hindi to explain you reasonable opportunity in Hindi. Sorry, boss. Seriously. If you want, I'll tell in Tamil. What is reasonable opportunity? In Tamil, I will tell. But Hindi, I cannot tell. Okay, sorry. Seriously, I would love to. But my loss that I did not learn Hindi when I was young. I preferred to learn English. What do you say? Okay. Sorry. Seriously sorry. Just look it up. Now what you do, you put it on Google, reasonable opportunity, meaning in Hindi, it will come. Let me see. Let me try that at least for my own knowledge. In Google, because sometimes, when you give these double words now, the language translator will give a totally different term. That will be dangerous. Let us see now. Since you asked me, I will do it. Uchit avasar. Uchit avasar. Avasar is, I suppose, time or something like that. Uchit avasar. Uchit means what is proper. Time. Not casual. So, Uchit avasar. That's what it means. Anyway, because Hindi is our Rajya Bhasha. Am I correct? Hindi is our Rajya Bhasha. But Rashtra Bhasha, we have 22. Plus 1, I think, 23. We have Rashtra Bhasha, we have 23. Hindi is our Rajya Bhasha. The two, as an amendment to Constitution, is bought under heavy pressure by Rajaji and Gandhi. It was bought. But then, even then, they said, this is not a single language country. We are a multilingualistic country. We have 22 languages, Rashtra Bhashas, where all can be used. In each state, they use different languages. Hindi is a Rajya Bhasha. Okay. Why I make this point, Hindi Rajya Bhasha, in a country like India, it's very dangerous unless multilingualistic country. So that's why. This is my view, not necessarily the view of the Institute of Chartered Accountants. Wonderful. Good. So Tanishka Batra will pardon me for this. Uchit avasar. No, I know that. See, I'm learning Hindi. See, Hindi is a language like any other language. I love to learn it. But then Buddha ho gaya na, what to do? Okay. What is Section 25 company? Yeah. See, in the old days, in Section 19, in the 1956 law, this Section 8 equal section was Section 25. Therefore, we used to call Section 25. So now you call Section 8 company. In those days, we used to say Section 25. Why in those days? 2012, we used to say Section 25. Then 2013 law came, 25 went away and 8 came, it became Section 8. See, if I say, I'll give a simple example. I give a very tough question and I ask you to give the reply immediately or within 1 hour. What you will say, sir, it's a tough question, sir. Please give me some reasonable time. Uchit avasar. You give me some reasonable time. So how long is reasonable? Depends on the person. Na? So even suppose you ask me a tough question and you insist, Mr. Srikanth, you answer now. Hey, I can't answer, yeah. I need time. So how much time? That reasonable time means, well, give me time, 1 day time, 24 hours. Like that, what is reasonable in law is there cannot be defined. It differs from situation to situation. Okay, what is reasonable will differ from situation to situation. But in that situation, you have to see what is reasonable and what is not. That is why when the matter goes to court, court will only finally say this is not reasonable, this is reasonable. Court will decide finally. Okay. You, Jayendra Kumar, customer, don't worry, it is my job. If I don't complete it, you sue me. What do you say? And it is not 3 sessions, it is 4 sessions. Okay. Sometimes students, I'm surprised at the way they think. Instead of concentrating on the lecture, why are you worrying about whether we can complete? Suppose I cannot complete, I will take 1 more session. What is there? I will complete it, don't I? My guru used to be very surprised when questions like this are asked. Students should know more about what is the topic, etc. Why are you bothered about can we complete it? See, when you worry about things like that, no, your ability to learn is being impaired by yourself. You are reducing your own ability to learn because your mind is so preoccupied with non-essential issues that you are not able to absorb the subject to the core. Always concentrate on what the teacher is doing. Don't worry, trust the teacher, you will complete it. And it's not 3 sessions, it's 4 sessions. That again, please note, it is not 3 sessions. What I'm doing is, I'll tell you, since Jayendra is such a technical person, I'm telling, I have 105 slides. I have 105 slides to cover. So what I'm doing is divide by 4. So around say 25 to 30 slides every session. That is my goal. So last session we covered about nearing 27 slides. So another 25, 26 slides. Around say Thursday, inshallah, Saturday. With that, it will be over. Don't worry. See, you asking this question, me answering, we have delayed it. I may be wrong. You are right. Whatever it is, Hindi is Rashtra Bhasha and others are all Rajya Bhasha. I'm sure you are right. I'm wrong. Whatever it is, we have 22 Rajya Bhashas. Agreed? And Hindi is our Rashtra Bhasha. Agreed? Recently, I read a nice, series of articles in Outlook magazine on this matter. If you want to be more intellectual, read that Outlook magazine ka issue on Hindi. And it's a very interesting thing. As a citizen of our country, everybody should read it. Even people who speak in Hindi. It's not as if I am a Hindi speaker, therefore. Suppose on the other, by a quirk of fate, by a sheer geographical peculiarity, Tamil Nadu is in the north and Uttar Pradesh in the south, and Tamil becomes the so-called Rashtra Bhasha. Still the issue will be there. Still it is wrong. Still it will be a problem for Hindi speakers in south who are unable to express themselves in Tamil, which is the Rashtra Bhasha. See, that is the problem here. Anyway, I don't want to get into an argument on this. It's a very, very emotional topic. But see, 3-4 generations have suffered with this language problem. Can we not change it in your generation? Can we not let go of this language issue and start communicating in a common language? Which could be anything, could be English. Think about it. English is the most logical language for common communication. Logical. If you take the emotional thing out of Hindi, English, it's the best language to communicate between us. In fact, we already communicate only in English. And which is why our country, we could not do away with English. When we introduced Hindi as so-called Rashtra Bhasha, we could not say no English. We said English is the state language, Hindi also Rashtra Bhasha, like that. You got it? Which why? Because we very well knew that below Vijayawada, nobody will understand. Nobody will be able to read. Maybe speak is okay. Read. So we played it safe and we said Hindi. So My humble request, see, one generation, 3-4 generations have wasted their time fighting on language. Everybody was wasting time. It's not only, everybody was wasting time on, which is why our country could not become the strong, country it could have become, because we are fighting on silly issues. Language is a silly issue. Language is a means of communication. Because 4 generations ka life we have spoiled. Some people don't know English. Some people don't know Hindi. Everybody doesn't know their mother tongue, except people who speak Hindi as mother tongue. Why? Bhojpuri? Gone. Odia? Gone. Going, gone. Bengali? Going, gone. These languages are dying. Okay? Think about it. It's a bigger point that you need to understand. Not what relevance it has for this subject, don't ask me. Ultimately, when you become a chartered accountant, remember, you're going to be one of the intellectuals of this country. Yes, you will be one among the intellectual population of this country, not just qualified person. You'll be considered as an intellectual in a society, in your city, in your neighborhood. As an auditor, you'll be on the top 3. Chartered auditor, doctor, lawyer. You'll be the top 3. You'll be any general issue also, you'll be asked to give your comment, because you are seen as an intellectual, not only as a accountant or tax manager or whatever. Go beyond that and think like an intellectual, which is why we have great people in our profession, who are intellectuals, like Gurumurthy and all, who are all intellectuals. Like that, we should. Anyway, thank you for acknowledging, sir, Mr. Mageshwaran. And of course, hey, Jayendra, come on. I understood what you are asking, but don't worry. I understand your concern. I will complete. In fact, in Bhagavad Gita, Krishna says, Idham vakshyam yaseshataha. In the 7th chapter, he says, Idham vakshyam yaseshataha. He says, I will explain this matter to you completely, aseshataha, without any balance, without anything left out, I will explain it to you. Don't worry. Like that, he will tell Arjun, humbly, I am saying that to you also, Idham vakshyam yaseshataha. Don't worry. Okay. Now, section 9. Very interesting. Is from the date of incorporation mentioned in the certificate of incorporation. From the date of incorporation mentioned in the certificate of incorporation, such subscribers to the memorandum and all other persons as may from time to time become members of the company shall be a body corporate by the name contained in the memorandum. So once a company is registered, from the date mentioned in the incorporation certificate, these people will come together and become a body corporate by the name contained in the memorandum. They will be capable of exercising all the functions of an incorporated company under the Act, having perpetual succession. So once the certificate of incorporation is issued, immediately this company will come into existence, capable of holding assets in its own name, capable of filing suit in its own name, capable of defending suits in its own name, etc., etc. It, as you can see, with power to acquire, hold, and dispose of property, both movable and immovable, tangible and intangible. So it can acquire, hold, and dispose of. And it has the right to contract. So when a contract is entered into, it is not entered into by a director or by a shareholder. It is entered into by the company. The director signs on behalf of the company as an agent. Okay. The company can file a suit in its own name, and it can be sued in its own name, right? This is important. When you come to final, you should remember this, that the company can file a suit in its own name. Now, this point, the company comes into existence from the date mentioned in the certificate of incorporation. Suppose by a clerical error or whatever, the name is wrongly mentioned. For example, the company was actually incorporated today, but the name is wrongly mentioned as day before yesterday. Date is wrongly mentioned as day before yesterday. Sorry, the company has come into existence day before yesterday. Got it? So even if it is wrongly mentioned in the, this was decided in a case called Jubilee Garden Mills versus Louis. Yeah, Mr. Joshi is asking this question, Suyog Joshi. Yes, I learned Sanskrit when I was 27 years old. Okay, because though it's neither a Rajya Bhasha nor a Rashtra Bhasha, somewhere I thought that could be my Matru Bhasha. So I decided to learn that also and be aware of what it is and grammar, and if not able to speak, at least I can read and understand Sanskrit. I got what is known as a Kovida in Sanskrit when I was 28 years old. Okay, now we go on to the two most important topics, documents for a company. When you want to prove who you are, your identity, one of the basic documents is birth certificate. That birth certificate is nothing but your certificate of incorporation. Right? Now, company also has the certificate of incorporation, but in addition to that, two more documents are very, very vital and important documents. You know them already, but I will take you through some of the concepts. The Memorandum of Association and the Articles of Association. Two documents. Somebody was asking me to show live memorandum and articles and all. I will do it. Though I had a lot of work and I had some other crisis and all, so I couldn't do it. So tomorrow I will ask my people to take a scanned image and then I will keep it ready for next class. I will show you. I will show you the certificate of incorporation, the memorandum. E-memorandum is there now. You upload the e-memorandum. The content of the memorandum is copied and pasted into the online format so that anybody wants, they can download it. In addition to that, we prepare a book also. I'll show you some of these things. So the Memorandum of Association, as originally framed and as altered from time to time, is called the definition of in the Act says memorandum means the memorandum of association of a company as originally framed or as altered from time to time. So the idea is in the Act, whenever they use the word memorandum, they mean memorandum of association. But come to the last line, the memorandum is the charter that brings the company into existence. See, think about it. How did India as a sovereign democratic republic come into existence? The day the constitution was adopted. So that event is a very important event. When the founding fathers of the United States of America signed what is known as a Declaration of Independence, the great country called the United States of America came into existence. So these are called charter documents. That's the Declaration of Independence, the Constitution of India. These are all called charter. They bring something into existence. So the memorandum is the charter that brings the company into existence. It is the base document for the formation of the company, and along with the articles is regarded as the constitution of the company. Equal to the Constitution of India. So the country we have constitution, for the company we have memorandum of association. And along with the articles, it becomes the total charter or the total constitution. But later on, we will see articles. Later on, we will in-depth see what is articles. Right now, let's understand memorandum better. It contains the objects for which the company is formed and therefore identifies the possible scope of its operations beyond which its actions cannot go. See, for you and I, we are natural persons. There is no restrictions on what we can do or what we cannot do. But an artificial person like the company should have some restrictions on what it can do. And people should know what it is capable of doing. Therefore, the memorandum clearly prescribes or circumscribes or reduces or restricts the operations. These are called objects. These objects are contained in the memorandum. Therefore, any person, the shareholder, creditor, any future person who wants to deal with the company, by seeing the memorandum will know what are the powers of the company, what are the activities it can engage in. And in case they are going to invest money or lend money, they would know for what purpose it will be utilized. Because it cannot be utilized for a purpose other than what is mentioned in the memorandum. Which is why memorandum is very, very important. See, today, that is why earlier what we used to do, we used to have some 5 main objects. And then we used to add a lot of other objects. So that whenever we want, we can bring the other objects into action. Today, no. Company can have only maximum 5 main objects. That's all. And it has to operate within that main object. In case you want to change You have to go through a process. Okay. So that main object should be related to each other. You can't have 5 different main objects. Suppose we are incorporating a company, cement manufacturing company, then 5 objects should be only cement related. Maximum you can have sale of byproducts, etc. But other than that, you cannot have some totally unconnected developing information technology parks and construction of buildings. Sorry, because you are in cement, you can only restrict to cement manufacturing and distribution. Right? So this is very important, so that people who are dealing with the company will know what are its powers. Later on, when you come to doctrine of ultra vires, you will clearly understand this importance. I will tell you again why. You will not understand doctrine of ultra vires unless you understand that the memorandum restricts the purpose for which the company can be engaged. The money of the company can be utilized. This is the protection of investor and the protection of creditor. But how? See, I am a shareholder, or I am a person who wants to invest in this company. How will I know what are the limits of what they can do? All I need to do is go to the registrar MCA website, because once the memorandum and articles are registered, they will become a public document. A memorandum is a public document under section 399 of the Companies Act. Public document means anybody can see it. No restriction. Non-member can also see it. So I can just go there. As I told you, in the MCA website, I think they charge some money for inspection, whatever it is. Actually, I have not done it. I will find out and tell you. But to my knowledge, they don't charge only for viewing. But if you want to download and all that, I think they charge you. So you can go and see it. Every person entering into a contract with the company is presumed to have the knowledge of the conditions contained therein. Presumed. See, I am the company. I have registered myself. My memorandum and articles is now uploaded. It is available for you on the website. Now, you can't tell me, no, I didn't see it. Oh, no. Why? Because it is there for you to see, boss. So the law says, even if that person has not seen it, it will be deemed as if he has seen it. I repeat, it will be deemed that he has seen it. Tomorrow he cannot say, no, I'm not aware of it. Nobody gave me the memorandum. Nobody will give you the memorandum. It is there in the website. Please go and see it. Even if you don't see it, even if the third party has not seen it, he shall be or she shall be presumed to have the knowledge. Presumed means deemed. Deeming is a very powerful topic. Later on, when we come to constructive notice, as it is called, I'll tell you a little more. This is called the doctrine of constructive notice. Constructive means deemed, presumed. Notice means knowledge. Constructive notice means presumed knowledge, deemed knowledge. Even if that knowledge is not there, it is presumed. It shall be as if that knowledge is there. So not only is it applicable to memorandum and articles, it is applicable to all documents filed with the ROC or uploaded on the MCA online portal. For example, later on, you will be seeing charges. Whenever the company borrows money and offers the asset of the company as a security, where the company's assets are offered as security, that matter should be informed to the registrar, to the MCA. It's called registration of a charge. When that asset is offered as a security, the charge is created. So that charge is to be registered. Once that is registered, it becomes a public document. So that if you are going to lend money to the company against that property, first you should go to the registrar's site, MCA site, and check out. On that property, has the company already borrowed money? You can. That information is available, public record. See, these are all protection of the investor and protection of the creditor. So we should use these facilities, right? So this is memorandum. This is the doctrine of constructive notice. Even if you don't understand at this stage, don't worry. When I come to doctrine of ultra vires, again we will discuss doctrine of constructive notice. But right now what you should understand, any document which is registered with the MCA, including memorandum and articles, is a public document. Any person who wants to deal with the company should go to the website and see it. Even if he or she has not seen it, it shall be deemed that they have seen it. That is the doctrine of constructive notice. Right? Now, what we are going to do, we are going to see the, shall we say, the clauses, C-L-A-U-S-E, C-L-A-U-S-E, clause. Santa Claus is C-L-A-U-S, Santa Claus. This is C-L-A-U-S-E. Clause means section like that. One portion is called clause. So in the Companies Act, we call it section, whereas in the memorandum, we call it clause. So we have 6 clauses in the memorandum. C-L-A-U-S-E. Clause means like a section. So the first clause is called name clause. Okay. Clause is a Latin term which means similar to section, like that. Okay. Point. Like that. So the first one is number 1, name clause. The name of the company will be mentioned there. Then, I wish I had done this, but I have not done it. If I can show you the, the actual memorandum, you will understand. The first line will be, the name of the company shall be Manar and Company, Dubakur Limited, whatever. Okay. The name of the company. If it's a public limited company, it will be self-limited. But suppose it is a private limited company, then you will say so-and-so private limited. Whereas for a public limited company, you will say so-and-so limited. Right? The word public limited is not used in India. Similarly, the word company is not used. We don't say private limited company. We say, for example, ABC Private Limited or ABC Constructions Private Limited. Okay. Beautiful. So, before we go there, let's see if any quick questions are there. AOA is not covered in MOA. It is another document in addition to MOA. We will be seeing it very shortly. Little bit, I will come when I come there. It's 2 documents are there. One is called the memorandum, which we are now seeing clause by clause. The next is the articles, which we will not see clause by clause, but I will explain what it is. Fantastic. Sweta Jain immediately says ₹100. Beautiful. See, the Ministry of Corporate Affairs is earning money like anything. Telling you, huge. And as I said, now for viewing, I think it's free. But for downloading, ₹100. Okay, they want to charge you because you see they have put some infrastructure. Somebody has to pay for it. Yeah, why not? They want you to know PAN and all. And so whatever they say, we have to do now. I don't know what to do. If you have any objection, the right person to speak is the Minister for Corporate Affairs. She, Nirmala Sitharaman, is the Minister for Corporate Affairs. Kindly talk to her if you think that is not correct. Himanshuji, the doctrine of constructive notice is a safeguard to the outsiders from the company, Baba. See, when an outsider wants to deal with the company, he will go to the public record and examine everything so that the company cannot cheat him. The public document will be telling the truth. So even if the company tells him some nonsense, he can go and verify it by the public record. So actually it is meant to other way. It is meant to protect the outsider from company. Right? Absolutely. You can see everything for free. Okay. Yes, just with Kaur telling. Yes, okay. Good. Excellent. Now, moving on. Memorandum. So we have the next clause is domicile. Okay. In the case of one person company, OPC, which is basically a private company, but one person, the name should have OPC Private Limited as suffix. So if you have Rajesh Khanna Industries, OPC Private Limited. Okay. So Rajesh Khanna Traders, OPC Private Limited, whatever. Now, the next clause is the domicile clause. domicile means state where the company's registered office is situated. In this clause, the address of the company will not be given. The registered office ka postal address will not be given. Okay. So, what you will have here is the state in. Why? Because, as I told you, in this country we have two jurisdictions. We have a state jurisdiction and we have a central jurisdiction. You and I come under both. Every citizen of the country comes under central government jurisdiction. But for certain matters, we have to come under the state jurisdiction. For some matters, we come under the central jurisdiction. Now, how will you know which state will be having control over this company? That is based on the domicile clause, the state in which the registered office of the company is to be situated. So, for example, many companies, especially in the north, will have a corporate office in Mumbai. But the registered office will be in Gujarat or in Madhya Pradesh. So the domicile would be there. Nothing wrong in that. They're not cheating anybody. Nothing wrong. They would have, for the sake of convenience, because they would have become a nationally present brand, it will be preferable for them to have a corporate office in Mumbai. But still, the registered office of the company will be in the state of Madhya Pradesh, Indore, state of Madhya Pradesh, whatever. Now, why not? Nothing wrong in that. Absolutely nothing wrong. Because it is publicly known. If you want to become a shareholder, you jolly will know the registered office in Indore. Then only you become a member. So now you can't say, no, they are keeping the registered office somewhere in Indore. Who don't? You knew very well it is in Indore because it's clearly stated the state in which the registered office of the company is situated is Madhya Pradesh. Okay, so what to do? Right. Only the state is mentioned here because then the government of that state will have control over this company for certain matters. For example, certain laws, certain taxes are levied by the state. So to that extent, he will come under that category, etc. Okay. So that is how you have to. Similarly, once you have your registered office in one state, any other state, if you set up an office, that will be a branch. That will be treated as a branch, right? This will become relevant for you in other contexts also, the registered office clause. Because when you come to management and administration, we will tell you the annual general meeting should be held only at the registered office. The annual general meeting should be held only at the registered office or in the same city, town or village as the registered office. When we come to management and administration, you should remember this. Do you notice one thing? Whenever I give you some information, I'm also asking you to remember it so that when you come to another topic, I will call for it. So please make a note of that so that you will relate it and talk. The objects for which the company is proposed to be incorporated. These are known as main objects and the matters which are necessary for furtherance of the main objects. These are called incidental or ancillary. See, for example, my goal is to manufacture cement, but to do that, I have to borrow money. I have to raise deposits. I may even have to lend money once in a while. I may have to invest. All that will come under ancillary objects. Right? Sir, are these clauses are compulsory or just a format? Sir, it's a format, they are compulsory. Every company should have these clauses in the memorandum. Without these clauses, the company will not be incorporated. And the objects should have minimum 3 objects and they should all be related to each other and they will be called main objects. Other than that, you can have ajar, ancillary and incidental objects. In fact, they themselves have given a lot of standard incidental and ancillary objects in the format. Yeah, but basically they are a format, but you can still, these are compulsory. You have to have. You cannot avoid it. For example, this is a very, very important legal clause. Because remember, why are you forming this company? Because you want limited liability. This is the clause which states that the liability clause mentions that the liability of the members is limited. In case it is limited by shares, it says the liability of the members is limited to the amount unpaid, if any, on the shares held by them. The last session we had a question and many of you answered correctly. When I said, when a company has got fully paid Ch-2 share, what is the liability? Many of you rightly said 0, nil. Okay. So The liability is limited to the amount, if any, unpaid on the shares held by them. In the case of a company limited by guarantee, the amount up to which each member undertakes to contribute in the event of the winding up. At the time of winding up, the member says, if it is wound up, I will pay so much. That is the limit of his liability. The amount he has guaranteed. That is why it's called limited by guarantee. So they agreed to contribute towards the assets and also towards the costs, etc. Okay. Yeah. Now, ancillary object, somebody is having a doubt. See, main object for you is to pass the CA exam, right? But you have to eat now. Am I correct? You have to buy clothes now. That is all ancillary, which are meant to support the main object. You can't carry on the main object unless you support this, you do this. Examples are entering into lease agreements, borrowing money, lending money, investing the funds, etc., etc., etc. Everything will come under the ancillary object. Okay. So the word ancillary means additional or supportive, in addition to, supportive of the main objects. You cannot carry on the main object unless you carry on the ancillary or incidental object. See, you want to visit your friend who is in Gujarat for her marriage. You have to go to Ahmedabad. So main object is to attend your friend's wedding. But to go to Ahmedabad, you should buy flight ticket or train ticket. That is ancillary, incidental. Got it? So that is not the main. Buying ticket is not the main object. But to go to Gujarat to attend the marriage, which is the main object, buying ticket is a incidental or ancillary object. This is the best explanation I can give for your question. The fifth clause is the capital clause. This is the amount mentioned in this clause is called the authorized capital, or the number of shares mentioned in this clause is the authorized capital of the company. The amount of share capital with which the company is to be registered and the division thereof into shares of a fixed amount. Later on, when we come to share capital, I will talk more about this. The shares of a company are same amount, fixed amount. Each share has the same face value. Okay. So this is the amount of share capital with which the company is to be registered. This is called authorized capital. More about it when we talk about separately. We'll come to share capital as a topic. At that time, I will tell in detail. But at that time, don't ask me what is authorized capital. Authorized capital is the amount, number of shares and amount mentioned in the memorandum as the number of shares with which the company is to be registered. Now, if you want to increase the capital, you have to change this first. Suppose a company is incorporated with 1 lakh shares. Authorized capital, 1 lakh equity shares of rupees 10 each. So the authorized capital of the company is 1 lakh into 10 lakhs. Suppose you want to now issue shares for 20 lakhs. You can't. Maximum you can issue only 10 lakhs. If you want to issue another 10 lakhs, you have to increase the authorized capital from 10 lakhs to 20 lakhs. We'll see that. How to, again you have to amend the memorandum. This is nothing but alteration of memorandum. You have to alter the capital clause. Okay, we'll see that when we come to alterations. Any provision in the memorandum or articles in the case of a company limited by guarantee. See, the capital clause of the company limited by guarantee will mention what is the amount each member undertakes to bring, like that. Okay. Company limited by guarantee may or may not have share capital. Suppose a company is there, it is limited by guarantee, it is not having share capital, then the provision in the memorandum of articles shall not give any person a right to participate in the divisible profits of the company, otherwise as a member. If the contrary is done, it shall be void. I'll explain this to you. Suppose I am forming an association. Now, sometimes, when I'm forming a Section 8 company, I will go for a company limited by guarantee without share capital. No problem. Why not? Why share capital at all? Limited by guarantee, not having share capital. 6 people form it. They say, in case the company is wound up, I will contribute 1 lakh, 1 lakh, 1 lakh, 6 lakhs. That is not the capital. That is the amount they agree to undertake to contribute at the time of winding up. Company is incorporated, no share capital. Company is making a lot of money, right? Now, maybe it's a society meant for promoting some welfare of some particular group of people. Now, so they will be having people who are engaged as members, who are admitted as members. Now, tomorrow, because of some, local issues, a non-member who is a relative cannot come and claim. Nor can the memorandum or articles, provide for that. Only member is entitled to participate in the divisible profits. Got it? So this is just a protection. So the idea is, later on we'll be seeing the memorandum and articles are basically a contract. The memorandum and articles are basically a contract. When the signatories to the memorandum, the people who are signing the memorandum, they sign it, they enter into a contract. It's a tripartite contract between the signatory, each and every one of them, the company. So each signatory enters into a contract with the company, and each signatory enters into a contract with every other signatory. So and any future person who becomes a member is being admitted as a party to that contract. Are you able to understand? When the memorandum, for the time being, you understand this. I'm signing. I'm a member. So I have a contract with the company now. Only I have the contract. Nobody else has a contract. No third party has a contract. Only I have the contract. I have a contract with the company and I have a contract with every other signatory. Later on, some more members are admitted. Now they will also have, once they apply in writing, they will enter into the contract. So that is an offer. And the share will be allotted now, or he will be admitted as member as per the procedure. See, where the company is limited by guarantee, still they will have member. But the admission of member, there will be some procedure. So and so people only can be admitted. Well, I don't know. For example, I'll tell you one example. That will be easier to understand. There are some dreaded diseases where, people who are suffering from that disease may come together to form a support group. The support group can be formed as a Section 8 company. So they will say only those people who are suffering from that disease can become member. I don't want to mention which disease, some disease. So membership is restricted to that. No problem. Because Section 8 company, they can do that. Now, once these members are admitted, the original signatory also will be of that category only. So all of them will have a contract with the company. Suppose I'm giving an example from not-profit company. Suppose for-profit company, no problem at all. The signatory to the memorandum will say, I'm taking so many shares. No problem. So they will have a contract with the company, contract with each other. Now one more person is coming. Suppose one of these signatories sells his share. Our company issues fresh shares. Whatever happens, new people come in. They are also bound by the same contract. We will be seeing this in a short while, but I'm explaining this. Okay. So other than member, nobody can claim, right? And otherwise than as member, you cannot claim. Only as a member, you can claim. Non-members are not entitled to any dividend or other participation in the divisible profits of a company limited by guarantee and not having a share capital. This is what it means in simple English. Right? Last clause. This is the contracting part. Contracting part. This is called subscription clause. Sometimes it is in those days, it used to be called association clause. In many of the older textbooks, you will find this clause listed as association clause. That is why it's called Memorandum of Association. Here the signatories. Signatory means person who is signing. The people who are signing are called signatories. So they will say, we the several persons whose name is mentioned below, are desirous of forming ourselves into a company limited by shares or whatever, and request that we may be incorporated as a company. Once they all sign, nothing happens. When the ROC issues a certificate of incorporation, there is a binding contract between each member and between the members. Inter se. Inter se is a Latin term. It means amongst each other or between each other. Okay. So there is a contract between the member and the company, and also amongst the members. Okay. There's a small change in the case of an OPC. Normal company, only these fellows will say, I'm undertaking to take so many shares mentioned against our name. We are desirous of being formed into a company. But OPC, you should also mention that name of that one person. For example, I. It is the seventh clause. Please understand, in addition to the subscription clause, there is a seventh clause. It says, I, whose name and address is given below, am desirous of forming a company in pursuance of this memorandum of association and agree to take all the shares in the capital. This is applicable only for one person company. So he has to mention. Okay. This seventh clause is applicable only for OPC. Also, there's an eighth clause where this OPC alone, it will be there, which says Shri or Srimati or so-and-so, son or daughter of so-and-so, resident so-and-so, shall be the nominee in the event of death of the sole member. So, if you connect this with OPC, here you should mention clearly who is that one person, single member. And also you should mention who is the nominee who will become the member in the event of death of the sole member. Right? So, this is mentioned. It's an for OPC, there will be additionally two clauses, 7th and 8th clauses. Got it? Let me see if you have any questions. Ms. Jain, Sweta Jain, your question is not clear. Would you like to tell which context you are asking this question? I can say I am eligible for only a year and after that I will not pay. No. Are you talking about guarantee? Are you talking about the guarantee? Company limited by guarantee? No. Once, see, later on, I don't know if you have been taught Contract Act or not. In Contract Act, you have a topic called guarantee, indemnity and guarantee. Okay. Only a continuing guarantee can be revoked. Normally, a guarantee cannot be revoked. Once given. Till the principal creditor releases, you cannot. So, guarantee once given. You cannot take it back. I will not pay. There is no time period in that. Guarantee is given. Wonderful. Jyoti Weather is from Ahmedabad. Wonderful. Nice. Beautiful city. I love coming to that city once in a while, and I enjoy walking on the Narmada banks. I love that. Let us see what happens. Some more questions are there. In case of limited by guarantee, if a person is leaving company before wound up, then what will be the provision? It's a good question. I'm not aware of the answer. You can't leave, is what I feel. Once for a limited by guarantee, you will be there. You can leave, but your guarantee will be there. That's what I feel. Actually, limited by guarantee, I've rarely seen. Company limited by guarantee, I've rarely seen. In fact, in my entire 30 years of practice, I've never incorporated a company limited by guarantee. Okay. Never has anybody come and asked me for it, to do it. Till date, 30 years. I've incorporated more than 1,800 companies in my own name. After that, some more companies I've incorporated through company secretaries. So, never have I seen. Even I've asked company secretaries whether they have done, nobody has done. See, issued capital, I will teach when I come to share capital. Right now, what you should understand, authorized capital is the amount mentioned in the capital clause of the memorandum. The amount mentioned in the capital clause is the upper limit up to which the company can issue shares. The actual shares issued is called issued capital. There is actual shares which are made available to the public is called issued capital. We'll talk about it when we come to share capital. Till then, patience. Okay. Today, there will be no break. Instead, I'm going to stop at 8:15, 8:15. I hope that's okay for you. I mean, that's okay. Don't worry. In fact, I'm going ahead of my schedule. In fact, I will be completing a little more than what I thought I could cover today, possibly because maybe the topic is fairly simple. No, not many questions or not many difficult questions for me to worry about and answer. See, that's a good question, Archie, where in the capital clause, we will mention separately what is the total number of equity shares maximum, what is the total number of preference shares maximum, separately. So we'll say the authorized capital of the company shall be 1 lakh equity shares of rupees so and so face value. Then 50,000 preference shares of rupees 100 each. Both will be mentioned in this class. Good question. Very good question. Amendment means change. When I formed the company, I would have had one memorandum and articles. Later on, I might want to change it. To amend is to change. So amendment is a change. So when you want to make any change in the memorandum or articles, it is called amendment or alteration. Right? Even the Companies Act is constantly amended. They will, at the time when they formed, they had one law. Then they made various mistakes. Slowly we pointed out and said, this is wrong, that is wrong. They kept on amending the law. Amending means changing. But to do that, they should get it approved in Parliament. Which is why, you know what these guys did? While forming the act itself, they said many things. They said, as may be prescribed, as may be prescribed. So that whenever it says, as may be prescribed, there is no need to amend it. The central government can itself prescribe. The central government will get the power to decide. That is why rules are very powerful in Companies Act. Many times, you know, the sections alone are not enough. We have to also combine the rules. It is making it a headache for a teacher. Everywhere you have to keep looking, act, rules, circular. Oh, they made it a mess. Earlier, the law was very simple. It was contained in the section. You read the section, everything was there. Now, from the section, you have to go to the rule. Then you have to link it with the section. Then amendment to the rule, amendment to the section. But anyway, it makes it more fun to do that. But then, for a student and for a teacher, it's very, very difficult. Main object is to attend the class to get knowledge, but the internet is supporting. Exactly. Beautifully said. This class, the main object is to conduct the class. But in order to conduct this class, we need to set up an infrastructure. That is incidental. Beautifully said. Very beautiful. Excellent. Jaspreet. Excellent. Beautiful analogy. In many of our ancient Indian works, you will find such analogies are there. Such comparisons are there. It's very good. Excellently said. Maximum amount to the memorandum. I'm not able to understand what it means. Mahadev Bharadwaj. Yeah. Maximum amount of capital up to which the shares can be issued, which is stated in the memorandum. If the member died, a good question again. In case the member dies, then his legal representative can claim. As through that member. Okay. Once the member is died, you can claim. As a legal representative. Because whatever rights he enjoyed, you will enjoy them. The legal representative will enjoy. What is perpetual succession member, madam? I'm asking you a question, Shweta Jain. What do you mean by perpetual succession member? I think you mean legal representative. Yes, legal representative member can claim through the member. Yes. This is for when the member is alive, somebody, otherwise there is member or somebody else cannot claim. What if the members to memorandum died or left the company? Don't say leave the company. Say left the company. Okay. Members of the name of Incorporation. As the company has perpetual succession, name of this member would be. See, the names mentioned in the subscription clause now will be permanently there. That will never be changed. Even if later on they leave, if they die or they sell the shares and go, nothing. The first people who signed the memorandum, their name will be there forever and ever. Later on, people may come, people may go, but the first 7 people or whatever, their name will be there forever and ever. Okay, their name will not be changed and all that. Instead, we will operate a register of members. Once the company is incorporated, they will have a register called Register of Members. We'll see that when we come to share capital and all that. That register of members will be updated. So the 7 people first, there will be the first 7 names in the register. Then if one of them is dying, we'll remove his name. And later on, when the legal representative becomes a member, we will mention their name like that. So that is register of members. Here nothing. Once incorporated, whatever is there permanently. See, this now that you are telling this, I had one major problem with one Chinese fellow. See, this guy is from Singapore. I tell you, the Singapore Chinese are the most difficult fellows to deal with. They are so suspicious. They will never trust you. And this fellow came to India and he wanted to form a company along with his wife. He came to India along with his wife and wanted to form a company along with his wife. I said, chalo, no problem. I'll do it. You both are Singapore people. I need your entire passport, blah, blah, blah. In translation, I want it notarized in your country and I want you to send it because he was in a hurry to go back to Singapore. I said, Baba, you sign it tomorrow. I said, no, I can't sign tomorrow. I'm leaving tonight. Okay, go. They send back everything. Then, no, I can't do that. I'm very busy, blah, blah. So for the emergency purpose, what I did, there was 2 other relatives of his who were Indian citizen Chinese in India. Chinese, a lot of Chinese in India. So Indian citizen Chinese in India. And I put their name and I incorporated the company. And I told at that time to this Chinese gentleman from Singapore, I told him, Baba, your name will not come in the memorandum. Are you clear? Oh, okay. Like that, he shook his head and he went off. Then the company got incorporated, he came. Then we transferred the shares, obviously. So those 2 people are honest people. So they immediately transferred the shares to him. He got it. Then I updated the register of members and I showed him. No. My name should be there in the memorandum. I said, hello, I already told you it cannot come there. Then only we allowed. Fellow kept on wasting my time, talking. I said, please go. Don't stand here and waste my time. Maybe in Singapore it is possible. Even in Singapore it is not possible. Fellow was just simply blabbering. So you got the point. If your name should be there in the memorandum, you should sign it. If later on the name cannot go in. Okay. I hope I have answered this. I hope it's not. I have not misunderstood your question. Special resolution. If you don't understand, you will have to be ignorant till we come to management and administration. When only we will teach you. Till then, special resolution means special resolution. Don't ask what it is. I will tell you at that time. Or me, hopefully I will tell you at that time. Very good, Darshanji. Vadodara. Vadodara also I have been there. I have been to this Sardar Sarovar. I've had the great opportunity of, seeing the Sardar Vallabhbhai Patel statue and all. I cannot say company limited by guarantee in Tamil also. If you are trying to catch me out, you have caught me, Mr. Surya. Okay, yes, Surya. Tamil company limited by guarantee, Tamil super. Hindi you can also kindly learn English. But I will try. I will try to find out and tell you later. Not today. I do not have a guarantee. See, each word has a meaning. But combining them will not give you the but it's a good challenge, but not today. Give me a reasonable opportunity to answer your question in the next class. Right, sir? Yeah, perpetual. See, don't use the word perpetual succession member, use the word legal representative. Yeah, legal representative, it can be asked. But he need not be out of his personal assets. Only out of the estate of the deceased it will be paid. See, suppose Mr. A has subscribed for partly paid shares, there is a liability. Suppose without the calls are not made, in the meantime our man dies, sir. The legal representative will come into the shoes. Now he will be liable for the partly paid share. but not out of his pocket. If Mr. A's bank balance, estate, etc., when he dies, he'll have some money, that is called estate. That money only will be used for making this payment. Got it? See, Tamil சொல்லணும்னா இப்படி சொல்லலாம். அதாவது அது அப்படியே தமிழ்ல டிரான்ஸ்லேட் பண்ண வேண்டாம். பட் சப்போஸ் ஒரு கம்பெனி வந்து இன்கார்பரேட் பண்றாங்கன்னா அதுல ஷேர்ஸும் இருக்கலாம். இல்லைன்னா என்ன பண்ணலாம்னா ஷேர் கிடையாது. அதுக்கு பதிலாக ஒரு 5 பேர் வந்து என்ன சொல்லுவாங்க, இந்த கம்பெனி என்னைக்காவது வைண்ட் அப் ஆச்சுன்னா இந்த கம்பெனியை மூடும் போது நாங்க இவ்வளவு பணம் கொடுக்குறோம், அது ஒரு கேரண்டி கொடுக்குறோம், இதுக்கு நாங்க உத்தரவாதம் தருகிறோம். உத்தரவாதம் தருகிறோம் அப்படின்னு அவங்க சொல்லலாம். அந்த உத்தரவாதத்தின் பேரில் உண்டாக்கப்படும் கம்பெனி தான் உத்தரவாத கம்பெனி, கம்பெனி லிமிடெட் பை கேரண்டி. அங்க வந்து அந்த கம்பெனியுடைய லைபிலிட்டி வந்து இந்த உத்தரவாதத்தால் நிர்ணயிக்கப்படுகிறது. அதாவது அந்த உத்தரவாதம் அவங்க கொடுத்த அந்த கேரண்டி அமௌண்ட்டுக்கு மேல அவங்கள கேட்க முடியாது அப்படின்றது தான் உத்தரவாதம் கேரண்டி கம்பெனின்னு சொல்லலாம் அப்படின்னு நான் சொல்லியிருக்கேன். Sorry for talking in Tamil, but then somebody wanted it in Tamil and then I've given it in Tamil. Hey, don't ask me to do it in Telugu, Malayalam, Kannada, I don't know. Okay, either English or Tamil, maximum Hindi, thoda. Okay. Special is nice questions. Some of you are asking very intelligent questions. How does a company without share capital work? Simple. These companies are not profit-making companies. They would be companies for some social object. So they will take donations and they will operate with the donation. So at the time of formation, 6 people will come and say, we guarantee. And that's all. The company will be started. Somebody will give donation and the donation will be used to run that company. It will be a not-for-profit, whatever you call, licensed under Section 8 company. Usually, most guarantee companies will be Section 8 company or association like that. Commercial companies will normally not go for guarantee because that is foolish, as you rightly say. How will they operate? Wonderful, Poonamji. So you're already aware of these topics because they were covered in Chapter 5. Excellent. I'm so happy to know this. Startup has been growing and wants to increase its authorized share capital. It has to authorize. If a startup has been growing and wants to increase its authorized share capital, it has to alter its memorandum. Yeah, it is cumbersome, which is why generally at the time of incorporation, they come to me. I ask them clearly what their goal is, so that if they want, I make it slightly higher at that time itself. Again, the fees is linked to the authorized capital. The fee payable for registration fee is linked to the authorized capital. So what I will tell, up to one slab, I will ask them to go and anyway the same amount is going to be paid. So I will ask them to take it up to the highest level and incorporate. See, subscription clause is the contracting clause. This is the clause by which the founders of the company will sign and say, we want to become a company. That's why, and they also agree to subscribe to the shares mentioned against their name. Suppose each man will say, so many number of shares, like that. And that many number of shares will be taken by that person. Okay. So that's why it's called subscription clause. Once the company is incorporated, they have to deposit the money in the bank and the share will be allotted to him and his name will be entered in the register of members. Okay. Mr. Puneet Yadav, I will teach special resolution when we come to management and administration. The comment given by you is wrong. That's all I can tell now. Okay. So 2/3 of members present and voting, proxy not included. Puneet from Gurgaon. Puneet Yadav ji, Aram se. When I come there, permit me to teach you. But if you know, then I will not teach you. Famous story. Man goes to a Zen master. He goes all the way up a mountain to that Zen master and asks him, I know company law, but there are still some things I don't know. Teach me what I don't know. Like that. So the master smiles and says, just sit down. Let's have a cup of tea. So they start drinking tea. One of the disciples brings hot pot of tea and 2 cups. And the master starts pouring. And then as he pours, he keeps on pouring. And the cup is overflowing and falling. Then the student, so-called student who came, he's saying, what master are you? You are keeping on pouring. You don't even know that the cup is full. Then the master says, exactly, my dear friend, your cup is full. Empty your cup, I will teach you. I'm not telling this to only Puneet. This is a beautiful story about learning. See, unless we open our mind, then nothing can be learned from a teacher. But if you already have some stuff there, sorry, what can I do? Okay. So don't worry, Baba. This time I have asked for management administration and I'm going to teach you. And I will teach you special resolution. As of now, let me assure you, 2/3 is not there. Okay. I also don't want to speak in Tamil, Maas. Just the gentleman wanted in Tamil and I told him. That's all. Okay. No. My humble apologies to those of you who don't know Tamil. There was a person who asked for Tamil. For him alone, I answered. In future, I will not talk in Tamil. It was a mistake. I apologize. He was asking, I said, 100%. I have already explained subscription clause to you. I have already explained guarantee in English. He wanted in Tamil, therefore I explained. Okay. See, think about it. In a country like India, if everybody wants explanation in their language, what will happen? Which is why we should be happy that for 200 years the British ruled us. And they taught us this wonderful language, which is the bridge language for all of us. And we should learn this language, which is called English, which is also good for us if you are going outside of India. See, think about it. That way, English is a superb language to learn. You learn Hindi, you learn Tamil, you learn Malayalam. I'm not saying don't learn your mother tongue or whatever. Rashtra Bhasha, Raja Bhasha, blah. But learn English. Do not ignore English and the power of ability to speak English in a country like India, especially at the higher levels of management. Okay, if you just want a government job, if you want a clerical job, Hindi is enough, Malayalam is enough, Tamil is enough. But if you want to be in a higher level in private sector, in this country, anywhere in this country, your knowledge of English should be very important. Sir, I have a question to name reservation. We'll come to name reservation. I will talk about name reservation in another class. In the next class, I will talk about it, or maybe this class. Authorized capital determine one can make. See, authorized capital is the choice of the members. Don't worry about that. Whatever they want is that. How they determine it, up to them. I'm not interested in even talking about it. Just they come to me, they say maximum I can talk to them and find out how much capital they are going to need. That's a case-to-case basis. Don't worry about that. Absolutely correct, Mantanjali. Finally, you got the answer. Subscription clause is the contractual clause between subscribers and company. This is what I have been telling again and again and again, but I think you've not heard. Now, finally, you got the answer. Sir, why the rules that come from time to time are called, for example, companies amendment rules? See, first came the original rules. Then any change will be called amendment rules. Any change will be called after the first rule. Even next day they make the change, that will be called amendment rule. In the same year, if they make change 2 times, the first one will be called amendment, the second will be called second amendment. Yeah, doctrine of ultra vires is a topic which we'll be covering on Thursday separately. I will be teaching it as a topic. Okay. Now, this is the format of the various kinds of memoranda. For example, if you want to form a company limited by shares, then the format of the memorandum is in table A. If you want to form a company limited by guarantee not having share capital, table B. Memorandum of association of a company limited by guarantee and having share capital, C. Similarly, unlimited company, where the liability of the members of the company is unlimited, not having share capital, table D. Having share capital, table E. Company, this is for memorandum. Articles of a company limited by shares, table F. So, basically, table A and table F will be maximum used. The rest of it is available, you can use. Table A and table F will be regularly used. The articles of association of a company limited by guarantee and having a share capital, table G. Not having share capital, H. Unlimited company, I. Unlimited company not having share capital, J. Now you might want to remember this, and because in the MCQ they may ask you this question. In the multiple choice questions, they might ask you this. Otherwise, I don't see a big need for you to remember. But suppose they are asking an MCQ, this is a nice MCQ to ask, easy MCQ to ask. We move on to name clause. Somebody wanted to know about what is that? Reservation of the facilitation of incorporation of a company. Why we can't use corporation word? I have a question relating to name reservation for the facilitation of. Sir, why we can't use corporation word? You can. With the permission of the central government, you can. We'll come to that point. For example, the Life Insurance Corporation Limited, LIC. It's there. The name stated in the memorandum shall not be, we have seen the clauses. Now we are going to see separately each clause. Then we are going to see alterations. How to alter that clause. So now we are going to see name clause. Here for name clause, there are certain conditions and certain rules. We are going to see that. First concept is that the name stated in the memorandum shall not be identical with or resemble too nearly the name of an existing company registered under this act or any previous company law. Means previous company law includes 1956 and on. So even earlier company law, if it's incorporated, it is a company. The word company is defined as a company incorporated under the Companies Act 2013 or any previous company law. So existing company means company registered under this act or any previous company law. So your company's name should not be identical with or resemble too nearly the name of an existing company. Too nearly resemble is where the danger is. For example, phonetic sounding is also there. The same pronunciation may be there. That is also to be avoided. Of course, you cannot be identical, similar. You can't have it. Okay. Or it should not be such that its use by the company will constitute an offense under any law for the time being in force. For example, there may be certain prohibited terms which you cannot use. So it will become an offense if you have such words. Similarly, there are, for example, if in that particular state there is a prohibition on gambling, you cannot say, or you cannot have a company which says XYZ Child Traffic Limited, Child Trafficking Services Limited. It's an offense here to do child trafficking, drugs and all. You can't have that name, okay, because it is offense. Also, it is undesirable. Certain names are undesirable, like that. Some names are offensive to the feelings of other people. Such names cannot be used. What is an undesirable name? First of all, a word or expression which is likely to give the impression that the company is in any way connected with or having patronage of the central government, state government, or any local authority, corporation, or body constituted by the central government or state government under any law. So, that is one of the reasons why the word corporation is not allowed. It gives the feeling, because usually the word corporation means, every city will have a corporation. So, it's a governmental, shall we say, name. So, you cannot use the word corporation, national, central, Indian, Tamil Nadu, Maharashtra. These are all, it gives the impression that you have some patronage from the government. So, if you still want to use it, you have to get the previous approval of the central government. That's all. So, if you still want to use corporation, then Maximum Finance Corporation Limited, no problem. You can go to the central government and get that. They will ask you why you want it, what do you want. They give it. If they see it's fit enough, they'll give it. Suppose they don't give, they reject the name, I'll tell you that there's a remedy available to you, but I will explain to you. When we come to, reservation of name, I will tell you. Right? Now, Thank you, Ms. Mantanjali, for accepting. You understood. A person may make an application. So before you incorporate the company, do you remember? You have to apply for the name, reservation of name. Today, what we do when you use Spice Plus, the name application is part A. So that goes first. The name is approved then. So you make an application in that form, Spice Plus part A, and pay the fee. And then you will 1,000 rupees fee. Then the registrar will then revert. Within 2 days, you will get an email. If the name is acceptable, they will give it to you. But if it is not, then they will say, sorry, they will not, you can't have this name. They will give you option to choose some more names. They will, I think you are allowed to do it 3 times. You can change. For the same fees, you can do it 3 rounds. Okay. Now, you will have to clearly give the name of the proposed company in case it's a new company. Or if it's an alteration of name, the name to which the company proposes to change its name. Suppose you already have one name, you want to change the name to something else, then you have to do this. I had a company which was called Blue Dot Consulting. Now, then I decided to change it. We have now changed it to the name Prometheus Consulting. Prometheus Consulting Services Private Limited. So this name got changed. And so I had to mention Prometheus. It so happened there was another company, Prometheus, some other name, but something to do. But luckily we got the name Prometheus. Okay, upon receipt of an application for reservation of name, the registrar may, on the basis of information and documents furnished along with the application, reserve the name for a period of 20 days from the date of approval or such other period as may be prescribed. So if your name is okay, then they will say your name is reserved, but only for 20 days. Okay, within that time, you have to incorporate the company. See, today with Spice Plus, it's automatic. Name is approved, straight away, Spice Plus, part B is there now. The company will be incorporated, certificate of incorporation come, maximum 3 days. From the time of uploading, 3 days, provided everything is in order. If there is any correction to be made, they will ask you to correct. If the memorandum or articles need some correction, they will tell you. Also, cancellation of name. Suppose they have reserved the name, but then it is found that the name was applied by furnishing wrong or incorrect information. Then, in case the company is still not incorporated, the reserved name will be cancelled and the person will be liable to pay a penalty for 1 lakh rupees because he has applied for that name under false pretenses. If the company has already been incorporated, be careful. There is a company means automatically a creature created by law. It cannot be cancelled. The certificate of incorporation, once issued, cannot be cancelled. You have to only wind up the company. So what they can do at best, it has been incorporated by giving false information. So they will direct the company to change the name within a period of 3 months after passing an order resolution. Or they will strike off the name of the company. Provided the company is not having any activity, they will strike off. Lastly, in case the company has already created some assets, borrowed money and all, then they will make a petition for winding up of the company. This is the only thing. That's why, once you create that company, bring it into existence by an act of law, only another act of law can kill it, which is called winding up. We move on to articles. The articles are the bylaws. The section definition says articles means articles of association, originally. But in reality, what is articles? Articles are the bylaws. They are the internal rules and regulations that govern the conduct of affairs of the company. For example, the incidental object will say, company can borrow money for the purpose of its main objects from time to time. So, power to borrow is there in memorandum. How to borrow? That will be contained in articles, where they will say, where the board of directors wish to borrow money, they can do so up to 5 crores. Beyond 5 crores, the company shall pass the ordinary resolution. All this will be contained in the articles, which is why you should read both memorandum and articles together, because they together. See, the memorandum is the charter. The articles are the bylaws, the internal rules. You have to read that to know. Especially if you are lending, whether the company has the power to borrow If so, you have to ask them to amend the memorandum and include it in ancillary object. Then, as per the articles, have they given any special condition? Up to how much can the board borrow? That you have to see. And then ask them, boss, your article says only up to 5 crores. Beyond 5 crores, if you want to borrow, you have to pass a special resolution or ordinary resolution. Has it been done? Yes, sir, we have done it. So they produce a copy. Then later on, when we come to doctrine of indoor management, we'll talk about this. Doctrine of constructive notice, doctrine of ultra vires, doctrine of indoor management. 3 together we will study. Sequentially, if you study, you will understand it. And this is very important there. Okay. The articles of association contain the regulations for management of the company. They can prescribe salary to MD, how it will be determined. Everything will be there. Standard articles, of course, is there. You can adopt table F. You can adopt table F, right? Sorry. You can adopt table F. Instead, you can go for your own articles also. Okay. Moving on. This is a new concept which has been introduced in the Companies Act. Before that, there is a question by Ayush Agarwal which says, sir, can we be exposed to Spice Plus practically, sir? Is it a module on MCA website? Or every function which we access from MCA websites can be referred as? No. Spice Plus is the incorporation of companies is a separate module where you have to go. Okay. Now, my dear friend, Mr. Ayush Agarwal, once you complete one group or both the groups, you will be joining what is known as, that is a different articles, not articles of association of a company. You will be entering into articles with a chartered accountant, articleship. You will become an apprentice with a member of institute. Maybe big 4 firm you will go, or maybe you will come to a small auditor like me. Somewhere you will go and you will be, for 3 years, you will learn as a chela from a guru. That man will teach you all this. Once you become an article clerk, practically we will expose you to spice, everything, GST, blah, blah. Because we have clients, you will get practical exposure. By working for us, you will learn practically how to do it. That is the beauty of the CA course. So at this stage, don't bother about practice. Practical. Practical will happen in articleship. At this stage, learn. Okay. So then later on, you will be exposed to spice. That is why we are having articleship. Don't skip articleship. Please, humble request. Don't do any nonsense and avoid articleship. Because CA learning comes not only from classroom teaching, not only from examination. 60% of a chartered accountant's learning comes from the 3 years of articleship. The 3 years of articleship that I underwent with my father, the greatest learning in my life. Rest of it I can mug up from book and vomit. I got All India rank. I'm an All India rank holder in intermediate, final, CA and ACS. 4 times rank holder. But what is the use? All that is only bookish knowledge. The real practical knowledge my father taught me as a student. I learned from my father as a chela. Not even as a student. I learned as a chela. And he taught me as a guru. Everything, every nuance he taught me. Practical. So if you want to have practical, yes, please ensure that it happens in articleship. And choose a good teacher. See, only big firms, yes, if you want more salary, they go. But everybody, every member of the institute has something to teach you. All of us have experience, we can teach you. So, go to a good person and Uttishtata Jagrata, Prapya Varan Nibodata. This is the Kathopanishad verse. You know what Swami Vivekananda ji said was different. He said Uttishtata Jagrata and don't stop till the goal is reached. Whereas the real Prapya Varan Nibodata. Okay, you go to the right teacher and learn. Okay? Go to the right teachers and learn. So that will come later. The institute program is meant like that. So don't put cart before the horse. Learn, then go. Which is why institute changed it so that earlier, the minute you completed your BCom or your foundation, or in those days it was called entrance, immediately you joined articles. Now they said no. One group. So we want you to come with some knowledge. And then we will teach you practical. Okay? Correct. Reynolds Stationery became Rorito. Check out. they would have changed the name. But then again, Reynolds is a brand. Rorito is a brand. It's a trademark. I really don't know if the company name was changed. Whatever the company name was. So I'm not aware. Maybe it was. Maybe Reynolds Stationery Limited became Rorito. So I know. CFM cannot be incorporated as a company, but it can be an LLP. It can be a limited liability partnership, but it cannot be incorporated as a company. Why? Because a company cannot be appointed as an auditor. Later on, we will tell you that a company cannot be incorporated as a CA Institute also does not permit chartered accountants to form incorporated companies. LLPs are allowed. Yes, correct. If not incorporated, you can. If it is not incorporated, the name reserved will be cancelled. The reserved name will be cancelled. That's all. But once the company comes into existence, gone. See, winding up is a chapter in the Companies Act. It's a chapter in the Companies Act under which you can go. Tribunal has the power to wind up the company. You'll study it when you come to final. In addition to that, there is also something called the Insolvency Code. Okay. So these are little overlapping. But basically, the Companies Act is a complete code. It has winding up provisions. It's a chapter in the Companies Act, which you will study when you come to final. Mr. Morias, good point. I think slowly India is moving away from the language issues to understanding each other, which is more important. Whatever language will facilitate understanding each other is more important than which is the more important language. Good. Himanshuji, later on when we come to name, alteration of name and all, we will talk about brand also. See, your name cannot, and again, remember, this word is very important. I'll show you. Identical with or too nearly resembles. So your Adidas and Adibas, just for the one BD, yes, it's not identical, but it resembles too nearly the name. But later on, you will see not only name. Suppose your company is incorporated with a name. The trademark of a person, then search for name in the name registry of the company law, ministry, government of India. There again. So, which means Adidas is an international trademark, which means they have international right over every country where they are signatories to the UNICITRAL. Since every member nation should respect the trademark of the other Americans. So that country, but I know for sure Adidas is a country will have to obey you, and nobody can incorporate Adidas. Adidas may be incorporated a foreign law. So every country, including India, should respect it. Can't Adidas B, Adidas D and all, you can't. he will understand when he hears. Anyway, another should include those three matters. Limit the number of its members to restrict the right to the public for subscription of any shares in or debentures of the Act. And means you want to do resolution or a special resolution. Chalo, good. But half the time nobody will use it. To my knowledge, nobody will use this. Simply it is there in the law. Okay. Good. We already saw the format of the articles, F, G, H, I, and J. But they can adopt these model articles. Okay. But they can also have their own clauses. Right. If you adopt the model articles and do not exclude anything, then those regulations will be the regulations of the company. Okay. Where the company has not made any separate provision in its articles and it has adopted the model articles, then the model article provision will be applicable if the articles are silent. Suppose the articles do not provide for investment of money. Model articles are providing for investment of money. Then that clause will apply. Suppose the articles do not provide for appointment of additional director, but model articles are providing, then you can appoint like that. So many things which are there in the model articles will automatically apply if you are silent. But if your articles is speaking something which is there, that will apply rather than the model articles. So where the articles are mentioning the topic, the articles will apply. But where the articles are silent, the model article will apply. So if you have adopted table F, you can still have your own classes. If any table F topic is covered in your class will prevail. But if you are silent, then table F will prevail. This is the usual rule. In those days, the format of the articles was contained in table A for your information. Now it is in table F, G, H, I, and J. Section 6 says the Companies Act 2013 will override the Memorandum and Articles because the provisions of this Act shall have effect notwithstanding anything to the contrary contained in the Memorandum and Articles or in any agreement executed by the company or any resolution passed by the company in general meeting or by the board. Whether the same is registered, passed, or whatever, the Act will prevail. Memorandum, articles, agreements, resolutions cannot be in contravention of the Act. Okay, the Companies Act is superior. Any provision contained in the memorandum, articles, agreement, or resolution, to the extent it is repugnant means unacceptable to the provisions of this Act, will become or will be void, as the case may be. Okay. So Act will override the Memorandum and Articles. See, you will note that section 6 starts with the words save as otherwise provided. Save as otherwise expressly provided in this Act. So wherever they want a particular clause to override, they will agree. Other than that, Act will always prevail. For example, appointment of additional directors, later on you will study it in final, but for example, I am telling, appointment of additional director, they will say, without prejudice to what is provided in the articles, without affecting what is provided in the articles. If the articles provide, that will prevail. But if the articles are not providing, then this will come. Like that only they will say. So wherever they have expressly said articles can be providing otherwise, other than that, no other provision can be contradicting the Act. Okay. For example, section 47 of the Act deals with voting power of members. There is a notification in 5th June 2015 that section 47 is applicable to a private company subject to its articles of association. So voting powers of members is dealt with in section 47. Now 47 is superior to articles. But that new notification or new announcement, notification means announcement. That new announcement of the government says, where it's a private company, then the articles can provide differently. Because 47 is applicable to a private company subject to articles. So this is an example of otherwise. So where they provide otherwise, where they say you can, then you can. So section 47 will operate fully for public companies. Whereas for private companies, the articles of association can provide otherwise. Okay. So in this case, the AOA will become superior. And section 47 of the Act will not be applicable. So these are all specific examples. Save as otherwise expressly provided in this Act. There should be a specific, either the section should tell like that or whatever. Okay. As I already mentioned, the Memorandum and Articles, when registered, shall bind the company and the members thereof. So there's a binding contract between the company and the members. So the company is bound to members, members are bound. Also, there is a contract between members inter se, but members are not liable to each other. Unlike partnership, where if one partner pays the loan entirely, repays the creditors, he can collect it from the others. Here, nothing like that. You pay what you are liable and go. I don't owe you, you don't owe me. So members are not liable to each other. But the Memorandum and Articles of Association constitute a contract between members inter se. So they are all bound by it. They are bound to the company, company is bound to them, they are bound to each other. Okay. All money is payable. Money means money ma. It's a funny way of saying money. All money means money. Payable by any member of the company under the Memorandum or Articles shall be a debt due from him to the company. Debt. It can be collected by the company as if it is a debt. Remember, the MOA and AOA create a contract between the company and its members and the members inter se. But a non-member, such as a director, has no right to sue under the MOA and AOA, right? So I want to close this session with the two case laws. I don't know what is the fate of my internet connection. I think many of you would have got angry with that. I don't know. To my knowledge, the connection is good. Anyway, let me reserve this for the next class to answer the question asked by my friend Mr. Jayendra Kumar. I am going on schedule. Train is on schedule. Today we were to cover up to here. I have covered. Today my goal was to cover up to here. By the grace of God, we have covered. Okay. So today, since I didn't give a break, I am taking the liberty of closing the session a little early. 8:15, I want to close the session, which I am now closing. I'm not going to cover the case laws and all. I'll do it in the next class. I'm sure you are not angry, but sometimes, you know, I will dramatically say certain things. Don't get worried by it, because I like to put things very dramatically. So sometimes I'll say you are angry, because definitely, you know, when you want to listen to the lecture and the internet is there, you will say, shit, why is this fellow not having good internet connection? Why not? After all, we are all human beings, right? To get angry is part of being a human being. Right? Good show. Aram se, learn the subject slowly. Don't worry about the PowerPoint presentation. It is only a notes. Great job of providing you with such, content. And to an extent, there are some excellent faculty. Maybe even an idiot like me is contributing something to you. But this is being done free of charge by the institute. Whereas many coaching classes are fleecing you. Your father and mother hard-earned money is being wasted on these criminals who are promising you all sorts of things and collecting money from you. My humble request, be careful. Unless the faculty is of really good reputation, please don't throw your money, hard-earned money of your parents or yourself in such things. Whereas our institute is providing so much available free. Kindly use this. Kindly spread this message to your friends. Put it on Tax Guru. We are putting so many things on Tax Guru. Put this on Tax Guru and tell people that this facility is available to them. As a member of the institute, I am humbly requesting you to do this. Wonderful. I wish you all the very best. Have a great evening ahead and looking forward to meeting you again in the next class. Thank you. Bye. So I'm closing the class, sir.